Our final case this week is Citizens of the State of Florida versus Clark, case number 22-94.
Good morning, and may it please the court. My name is Allie Westling on behalf of the Office of Public Counsel, and I have the privilege of representing the citizens of the state of Florida, and specifically the customers of Duke Energy Florida in this matter. I would like to reserve 5 minutes of time for my rebuttal. We're here today because of the Public Service Commission's improper decision to go with their gut rather than follow the law. Despite explicitly finding that Duke's actions directly led to the outage at Crystal River Unit 4, the Commission nevertheless ordered customers to pay half of the $14.4 million in replacement power costs which were incurred as a result of that outage.
Counsel, before you get into kind of the merits, can you address Duke's assertion on the preservation issue?
Certainly, Your Honor. With regard to the preservation issue, OPC maintains that we have appropriately preserved our arguments. We feel that there are constitutional statutory protections that require, that give this court mandatory jurisdiction over this matter, but at the end of the day, worst case scenario for OPC, if the court finds that OPC's withdrawal of the motion for reconsideration led to the abandonment of the issues, there are serious due process violations which occurred in this case, which resulted in fundamental error. And if you'd like, those due process violations consist of a violation of section 120.57(1)(b) and 120.57(1)(j).
But the first time those were raised was in your reply brief, right?
Yes, Your Honor. However, that means fundamental error allows for raising issues for the first time in the appeal. So that's the situation that we have here.
But typically, I mean, in an appeal, the appellant has to raise the appellant's issues in the initial brief. It's not something that you come up with an argument for relief for yourself in the reply brief.
I think one unique circumstance here is that we came straight from the Commission's order to the Supreme Court. There was no intermediate court or district court of appeal where that issue was brought to our attention. As I said, we maintain that we preserved our arguments, and until the answer brief was filed that contended otherwise, we believed our arguments and continue to believe that our arguments are preserved.
The trouble with that, though, is that you first filed and then withdrew a motion below. Why'd you do that? Why didn't you just get a ruling?
There are several reasons for the withdrawal. Unfortunately, none of those reasons are or could have been captured by the record, so I can't really go into those. But what I can say is that the due process violations that occurred here.
You know, I hear you on the due process front. We've heard that argument, but we're stumbling a little earlier in the discussion, which is assuming we don't go to the last refuge of the scoundrel on due process. It sounds like you're conceding that if you had to do it over again, you wish you would raise these issues in the first instance in your appeal brief, or it sounds like we wouldn't be in this pickle at all if you'd just gotten a ruling on your motion below, and so it seems to me at least like a pretty textbook case of waiver of this issue because you've failed to raise it properly on appeal. Help me out here. Without going to the due process thing, do we agree that on the just like frontline question of whether or not it's been appropriately raised for appeal, it hasn't been?
I don't concede that, and the reason for that is because of the current reading of Rule 9.020 on the effect of a motion for reconsideration. 9.020, I believe it's sub 2, 3, or 2G if I'm not mistaken, says that, it currently says anyway, that when a notice of appeal is filed and there are pending motions for reconsideration, that the withdrawal of a motion for reconsideration, or excuse me, that the notice of appeal is held in abeyance until either a ruling on the motion itself or the withdrawal of the motion. Now, the rule used to say that there used to be a sentence in there that said withdrawal of the motion for reconsideration is tantamount to abandonment of the arguments. The rule does not say that, and when we withdrew our motion for reconsideration, that was not that was not contemplated. We felt that since we had our motion for reconsideration.
But the whole idea behind the requirement for the preservation of an argument is to give the tribunal below the opportunity to address the issue. And in the sequence of events here with that withdrawal, you kind of jump beyond that, and you had an argument that could have been presented by way of the motion for reconsideration, and you didn't pursue it. And so we're here talking about it when this perhaps could have been resolved at the by the lower tribunal in the commission. So I just think if you're looking at preservation, this just seems like a kind of a classic case of based on the law that's out there in this administrative context, that you've got to raise issues that in a motion for rehearing if you've not had an opportunity to do it before, I'm just struggling to see how you get around that in this context.
Sure, I have 2 points that hopefully will help with that. First of all, nothing about our withdrawal of the motion for reconsideration prohibited the commission from, of their own volition, issuing an amended order or taking their order back and fixing it. And I would also point out—
Well, except you said never mind. I mean, effectively. I mean, why would they pursue something when you've said never mind?
Well, also, hadn't you filed the notice of appeal the same day?
No, Your Honor. The sequence of events was the order was issued on December 21st. Mm-hmm. On January 5th, OPC filed the motion for reconsideration. Okay. On January 20th, OPC filed the notice of appeal. And on January 25th, so 5 days after we filed the notice of appeal, we withdrew the motion for reconsideration. The other thing I would point out as far as how the commission is not harmed by this is that their own answer brief, they didn't raise this issue. They acknowledged the court's mandatory jurisdiction over this matter, and at any point in this—
But mandatory jurisdiction is a separate issue from preservation. We have cases over which we have mandatory jurisdiction in other contexts where if an issue's been waived, if it's not been preserved, it's been waived. So that's a category confusion. And what am I missing when I say that?
I believe that the bottom line is that as far as we stand here today, the commission stands by this order, and they could have even filed a motion for relinquishment from this court if they found that they had erred, and they have not done so. They have doubled down on their position that this order is a good order.
Well, I understand that, but the issue is, well, okay.
Look, I mean, you have an argument that where there's no preservation issue, and you're either going to win or lose on it, I think, which is they had the burden of proof to prove prudence. You're saying that they didn't prove that. That's been in dispute right from the beginning. It's in dispute throughout the whole thing. That's the whole subject matter of the order. That's what this appeal is about. So, I mean, can you focus on that?
Yeah, from OPC's perspective, the issue of the preservation of arguments is not dispositive of the matter of prudence. The issue on the motion for preservation, as I've said, and as are relayed in our reply brief, which again was written after we were first aware of this argument that they've raised for the first time on appeal, if you look at it that way. Once we were made aware of this argument, again, in their answer brief, our first opportunity to reply was in the reply brief. We did so. We laid out all of our issues there. And on top of all of those issues, due process violations are fundamental error, even if arguments are unpreserved. And there are a number of cases, the Pumphrey case and the Verizon case cited in the reply brief, stand for that position. So ultimately, the preservation issue is not dispositive of the prudence issue, which is what we really should be discussing, which is what I hope we can discuss more. The 5 flaws in this order are, again, laid out in the initial brief. But essentially, the first argument is that the commission erred by erroneously interpreting a provision of law, essentially the Cressy standard, which is a Supreme Court case which lays out that, and it's been well established, that utilities bear the burden of proof when they seek to recover costs. And with the Commission's finding that Duke's poor decision-making directly led to the outage in Crystal River Unit 4, but then ordering customers to pay half of those costs is an inappropriate interpretation of the Cressy standard. Additionally, the Commission acted outside their range of discretion. Court must not allow, although the statute says that their powers are to be liberally construed, that does not mean they can eliminate the burden of proof, and this court must not allow them to do so. The, the Commission also acted inconsistent with their prior agency practice. They have never before allocated costs for a single outage event, and they have never before cited mitigating factors for any of those reasons either. The 2009 fuel case, which I cite in the initial brief, stands for the typical case where the Commission takes in evidence, they look at, they weigh the factors, and they determine whether or not the utility met their burden of proof. And they're very explicit about that. However, obviously this order is missing all of that analysis. There's a long chain of cases that precede that 09 and follow that 09 case, which show the Commission's common practice. The Commission also, by introducing this for the first time ever, and after any party could present evidence or argument on it, this concept of allocation of costs and mitigating factors, those mitigating factors aren't even supported by competent substantial evidence. Again, 120 sub 57 1J says that findings can only be made on evidence in the record. And the Commission verbally said they're going with their gut. They don't know what facts to base this on, but they're going to just go with their gut and split the baby here.
Well, the going with the gut was more about the 50-50 split, the decision to make it even, correct? I mean, you would say that there is evidence in the record to support the mitigating factors, that the machine did not operate as it was supposed to when the operator attempted to fix this problem manually.
There is evidence of a faulty relay. However, that evidence is a complete red herring in this case, and there is zero evidence in the record of what percentage of the $14.4 million that failed relay caused. There's also zero evidence in the record of how much of the replacement power cost that continuing to do something wrong causes. I mean, there is zero support in the record of any dollar number to support either one of the mitigating factors. And when you consider that on top of the fact the Commission has never even considered mitigating factors or allocated costs before, this is improper. Additionally, the due process violations.
Let me help me understand the facts, or your understanding of the facts. Is there evidence here to support the conclusion that this adverse event would not have happened but for the occurrence of both the operator error and the relay failure?
On record site 1869, Duke's own witness says that had the operator flipped the breaker at the appropriate time, no damage would have occurred.
Well, I understand. I'm talking about operator error. I'm saying that, okay, we know that operator error happened, right?
Correct.
I mean, I don't think that's disputed. And then but I'm asking about the relay failure, if I've got the term right. If the relay had not failed, is there evidence that would show that the operator error would not have caused the problem?
I believe there are sites in the record. However, when you think about it chronologically, whether the operator properly flipped the breaker at the right time precedes whether or not, and the importance of whether the relay was working. It's the operator's error that is the key to this analysis. I
understand that's your position, but I think that there's the factual pattern here is there are these two different things that went awry, and both of them had to go awry for this adverse event to happen. At least there's evidence to support that conclusion, and you admit that, correct?
I believe there is evidence that that potentially could support that conclusion. However, when you look at the Commission's own order, they did not have to pick a direct cause. They could have said these two things together caused this outage. They did not do that. They said, in sum, failure of the plant operator to follow written procedures without supervisory approval directly led to the outage at Crystal River Unit 4. They weighed all of those factors. Their order shows them weighing those factors, and then they conclude that the one and only direct cause of this outage was Duke's error.
Well, they talk about two causes, but I think from your perspective, the issue is the burden of proof was on the company to show that they acted prudently. One of the things that they could have proved and that could have been found potentially by the PSC was that it was prudent to rely on this relay. Essentially, I mean, I'm not an engineer or whatever, but it seems like this is a mechanism that's supposed to make it idiot-proof, so that if people just sit there, hitting the button repeatedly, that it's going to essentially make it so that that doesn't cause a problem. And the PSC could have found that between the relay working the way it normally does and the fact that this guy had done this before, that it was reasonable, that it was prudent for them to go ahead and do what they did. But they didn't find that. Instead, when it comes to the actions of the company, which is the only thing at issue, that they were imprudent by not following the procedures, and yet they still gave them $7 million. Isn't that the bottom line?
Yes, Your Honor, and not only does the order say that that's the Commission's ultimate finding of fact on this matter, their own vote sheet at record page 91, they have the Commission, every single Commissioner signed that on the day they made their ruling, and there are handwritten strike-throughs of the portions they disagree with. Well, the only thing that's not stricken through, the part that they unanimously agreed on, is that failure of the plant operator to follow written procedures without supervisory approval directly led to the outage at Crystal River Unit 4. They obviously had a pen. They could have written in and said, and the relay caused the outage. They did not do that. The Commission made a finding of fact, and the only natural conclusions that can be drawn from that ultimate finding of fact are that Duke was imprudent and therefore failed to meet their burden of proof. And I'd like to reserve the rest of my time.
Good morning, and may it please the Court. My name is John Rubottom, attorney for the Florida Public Service Commission. To begin with, I'd like to say that, Justice Kennedy, I think you've identified the issue at the heart of this case, which is the Commission did find that there were two causes of this outage. Now, I think it's important to point out that while the final order did and does say that the deviation from standard written procedure directly led to the outage, it does not say, nor does the discussion in the final order indicate that it was an independent cause. And in fact, the recommendation with which the Commission disagreed at the agenda conference included language that said directly and independently led. That language does not appear in the final order, and if the discussion at the agenda conference is entirely about the responsibility for the outage, the causation of the outage, and one of the commissioners indeed stating that
I think, though, that you're kind of mixing things. I mean, the causation thing seems like that's not really, what the issue before you guys came in, not you, I'm sorry, the company came in and said we had to buy these, this replacement power. We acted prudently. We want to recover those costs, right? And so the issue before the Commission is given what was facing the company, did they act prudently? And it seems like as to prudence, the only finding that in terms of what the company itself did was that they did not act prudently. And in your brief, you say that the order allowed recovery of DEF's prudently incurred costs. I don't see that in the order, and if it had said that, I don't even know how you would support that, because how does the fact that the relay broke make that a prudently incurred cost? Unless, again, it would have been prudent to rely on the relay essentially to protect you from your own errors, but the PSC didn't find that.
Our position on that is that it's true that there was no explicit statement, but the standard is costs are recoverable if prudently incurred. And so simply the granting of recovery is an indication that the Commission found that some of those costs, 50% of those costs, were prudently incurred.
But can you explain the chain of logic that would get you to that conclusion?
Certainly, we're happy to. The chain of logic is that imprudent actions, unless they give rise to and cause the outage and the cost to be incurred, is not a basis to deny recovery. So causation is implicit in this analysis. And in this case, the Commission found two independent causes of the outage that, apart from either one, they are both causes in fact. They both occur in the chain of events leading to the outage. And had either one of them not occurred in this case, the outage would not have taken place. The cost would not have been incurred.
Can you point to the point of the report that says that the failure of the relay to properly work was a cause? I mean, I understand they've considered it mitigation, a factor to be considered, but I mean, it says that it was operator failure that led to the outage. And then it said, but this other thing happened that was a factor. Where does it say that that was a cause?
That the failure of the device itself was a cause?
Mm-hmm.
In the sense that it's a cause in fact, that because it failed, because it was not operating, it was a cause. It did not function as designed.
You can't say it was a sufficient cause. You might be able to say it was a necessary cause, because absent that failure, it might have, had there been no operator error, we wouldn't have known. But can you concede, I think you have to concede, that while not a sufficient cause, it is a necessary cause of what happened?
Yes, Your Honor, we do agree that at the moment the relay failed or went into a failed condition, that did not cause the outage. But in the chain of events, this operator making these decisions and actions, the reliance on the relay, that taking actions he had done in the past with no adverse consequences, in this case, there was a condition he was unaware of that led to and contributed to causing the event. So again, our position is that the causation, the fact that two causes were found, those were factors leading to the outage. That was the issue the final order was dealing with, and the Commission was examining the utility's prudence with respect to those causal factors.
Well, okay. Go on.
No, go ahead.
I was just going to say, I think this takes us back to where the Chief was, which is that this is a very interesting discussion about causation. Let's realize that that's only one component of the prudence determination, and that they bear the burden. And you find, I think you'd have to say that on sort of a mixed, you've got a mixed bag here. Help me understand, is it the Commission's position that Duke met the prudence standard in this case? And if so, help me get over that hump, because I struggle with it.
Certainly, it is our position that Duke met its burden of proof to prove that costs were prudently incurred, and that the Commission's role in that instance was to allow recovery of prudently incurred costs. And again, those facts that are discussed and summarized in the final order.
Then I guess the question then becomes, let's say that there is a basis for recovering prudently incurred costs. Why is exactly 50% of what this cost, the amount of cost that is prudently incurred, as opposed to the whole amount? Like, why? What's that about? I mean, is that really ultimately about gut?
We believe that that OPC is mischaracterizing that discussion. It is about a judgment call. It's about the Commission's discretion. This ultimately is a case involving rate making. The allowance of prudently incurred costs to be recovered through rates, that's what this case is entirely about. And so when the Commission is faced with evidence indicating that two combined factors led to causing the outage and the cost to be incurred, and has no indication that either one of them could have caused it on its own, the Commission's position is that it's within the Commission's discretion under the broad rate-making authority to grant recovery of half of those costs. It's a fair, just, and reasonable outcome under the Commission's authority to set fair, just, and reasonable rates. So that's the basis for the 50% for the allocation.
Can you direct us to where we find this elaboration in your order as to the basis? Because it seems like, and this is a recurring issue, it seems to me like perhaps you can't. Like we're left with very little in the way of a record demonstrating the considered judgment that you just articulated. I'm hearing it here, oral argument. Is it present on the face of any order or any conclusion?
We believe that the agenda conference, the discussion is very much about how do they determine causal responsibility. It's an entire discussion about the responsibility and how to measure it. They disagreed with staff's recommendation that there was that the utility's deviation from standard procedure was the single cause. So again, it's an exercise of their discretion. It's not summarized explicitly in the order, but we don't believe that that's a basis to overrule or to remand on that basis. And I see I'm nearing the end of my allotted time, and with respect, we request that the court affirm the final order.
May it please the court, Daniel Norby and Alyssa Corey from Schutz & Bowen on behalf of Duke Energy Florida. Unless the court would prefer otherwise, I'd like to start by addressing two questions that we think are dispositive of this appeal. First, did the commission find that Duke Energy carried its burden to demonstrate prudence with respect to the CR4 outage? And two, if so, does competent substantial evidence in the record support that finding? If those two questions are answered in the affirmative, we would submit that this court need not reach any of the other esoteric issues that have been raised by the Office of Public Counsel in order to affirm the Commission's order. So the first of those questions, did the Commission find that Duke Energy carried its burden? You've heard from Commission's counsel that that was their finding. We think that is necessarily true, even if not explicitly stated in the order. And that's because the Commission outlined the burden of proof at page 28 of the record, clearly established that Duke Energy bore the burden of proof to demonstrate prudence in this appeal. And at the end of the order, the Commission awarded replacement power costs to Duke Energy. It could not have done that without finding that Duke had carried its burden to demonstrate prudence.
But wouldn't but I mean, in terms of the issues that were in front of them, it seems like in terms of their affirmative prudence, the only way that you would get to that is if they had said that it was reasonable to rely on the guy's past experience with not having had a problem doing it this way, and just general, faith in the reliability of the machine. That satisfied their burden, in which case it seems like the right answer is 0. But instead they basically said, it seems like they concluded that it wasn't reasonable, that they still, that the reasonable manager would have gone through the steps and done all that, in which case, the answer should be that that they should get all of it versus none of it. It just seems like those are the two options.
Well, and certainly on that issue, the amount of costs is a separate issue, I think, from the prudence determination itself. What we're suggesting is that if the Commission found that Duke Energy satisfied its burden to prove to demonstrate prudence here, then is there competent substantial evidence in the record that would support that finding? We'd submit that there is. The testimony of our witness, Joseph Simpson, and the root cause analysis have abundant evidence of that this was a trained operator, that he pulled this lever 1 second. If he'd pulled it 1 second later, this would not have occurred. If this highly reliable relay had not failed, then this outage would not have occurred. There are a lot of things in this record, the evidence before the Commission, that would support a finding of prudence here. Competent substantial evidence is a low burden here. The court's task is not to weigh the evidence on both sides, to see if there's evidence supporting that finding of prudence here. And we think that is a necessary finding here because there was an award of costs, and as you've heard from Commission's counsel, the Commission found that Duke had carried its burden of proof here. On the second question, though, Chief Justice, on the amount of the costs here, we don't think there's a need for the court to reach that issue and the Commission's decision.
Can we back up for a second, though?
Okay.
I don't understand why we should be trying to do all these mental gymnastics that you're talking about on inferring findings when the stuff that's on the page addresses the question, and they didn't find that it was prudent to rely on that stuff.
Well, I disagree with the characterization that OPC's counsel made on that causation question, because I think that's a category confusion. Causation does not demonstrate imprudence here. proximate causation is a necessary, but it's not a sufficient finding in order to demonstrate imprudence. There are cases that we've cited in the briefs where there's no question that where a utility relies reasonably on advice that's given to them by a consultant causes an outage, but their reasonable reliance on an expert can still be prudent action, notwithstanding the causation.
Right. But the PSC is conflating causation and prudence. I mean, that's their whole argument. Is that there's two causes and therefore it's, you should only bear, I guess, this rationally arbitrary 50-50 split.
Well, there were two causes that independently would have had to come together here: the failure of a highly reliable device and human performance error by closing the circuit 1 second early. The question then is are the actions of a highly trained operator here and the failure of an equipment, does that come together to demonstrate that Duke was prudent in its actions here? We think that evidence would support a finding of prudence here. A human performance error by a highly trained operator does not demonstrate imprudence by a reasonable utility manager.
Fighting against that's fighting against what the PSC itself found. I mean, if there's one thing, how they're factoring in the machine failure is, the logic on that is murky. The logic on their finding of imprudence by the operator is not murky at all. They basically say, at the end of the day, you're not a bad guy, it wasn't intentional, you guys weren't, recklessly indifferent or whatever, but the bottom line is you didn't have written procedures, you didn't have training, you didn't do what you were supposed to do, and as a result of that, the outage occurred. That's crystal clear in the order.
I disagree with that as to the training aspect. The evidence was that he was a highly trained operator who made a human performance error here. What they say at page 30 of the record, what the Commission's order says, is that failure of the plant operator to follow written procedures without supervisory approval directly led to the outage at Crystal River Unit 4. It doesn't say, and therefore the conduct of the utility was imprudent. It's a causation finding, it's not an imprudence finding in our view. The second question that I wanted to get to, though, is the issue of the costs and why this court doesn't need to reach that issue. Because if the Commission found that Duke had carried its burden as to prudence, and if competent substantial evidence supports that finding, then the aggrieved party, if there is one, as to the reduction of the cost from 14.4 to 7.2 million, is my client. My client has not challenged the cost reduction in this appeal. OPC, I don't understand to be saying that the only option here upon a finding of prudence is a 14.4 million. We've chosen in this appeal to accept the Commission's reduction in the costs, and this court therefore does not need to reach the issue of whether it reduced those costs appropriately, whether it departed from precedent in doing so. My client would be the aggrieved party. We've not challenged it in this specific appeal, so we don't think you need to reach that question for two reasons. One is the issue of preservation that the court addressed with my friend on the other side here. Any issues about mitigation or allocation of costs were first raised in a post-hearing motion for reconsideration that was withdrawn inexplicably without any decision on it. So I think there's a preservation issue that should prevent this court from reaching the reduction in costs. The second issue is akin to an issue of standing here. If the costs were reduced from 14.4 to 7.2, OPC is not adversely affected by that decision within the meaning of 120.68, such that they have the ability to assert that it should have been taken from 7.2 down to 0. Again, the issue there is the reduction from a 14.4 to a 7.2. If you accept my premise at the beginning that the Commission found we had satisfied our burden as to prudence and that there is evidence in this record, notwithstanding that there might be evidence going both ways, if there is competent substantial evidence in the record supporting a prudence determination, then those are the only issues that this court needs to reach.
Where it says that the way this went down is very troubling and does not constitute acceptable operational practices, you want us to read this as saying that you were prudent?
If the Commission had not found that we'd satisfied our burden, it would not have made an award of cost recovery here. What the Commission said, and this is the case in... So
basically, so we should just assume that regardless of the words on the page, we just should assume that if that would be a bizarre standard of review, that we can ignore what you actually say and just kind of assume that you must have somehow magically properly interpreted the law to make what you did acceptable?
Well, the commission does not make any explicit finding of imprudence in this determination. They summarize the evidence, and this is something that we've seen in several commission orders, is sort of a summary of the evidence on both sides and then a decision at the end. But we think necessarily the commission found that Duke satisfied its burden of proof, or it could not have made an award of a cost recovery here. It would not have been proper to have done so in this case. We think they did find, based on the evidence before them, the evidence of the witness that the commissioner said at the agenda conference was credible, that he gave a lot of information about the specific procedures that happened here. This was a procedure that had been successful in the past. It would have been successful here, except for the failure of a device 1.5 miles away that no one could have known about. All of those factors together would support a finding that even if something happened here, a bizarre confluence of circumstances that led to this outage, that doesn't mean that a reasonable utility manager would have done something different in these circumstances. Human error is not evidence of imprudence in this setting. So there may have been evidence, and OPC has cited some evidence suggesting that certain things could have been done differently. Our root cause analysis that's in the record here suggests that some things could be done differently. But at the end of the day, the fact that these circumstances caused the outage is not in dispute here. The question is whether it was imprudent. Duke Energy was imprudent in the way that it acted here. We think the finding and the Commission's award of cost recovery here amounts to a finding that Duke carried its burden and that evidence supports that. Unless the court has further questions, we'd stand on our briefs for the remaining issues. Thank you.
Thanks.
Thank you again, and may it please the court. Speaking of raising issues for the first time on appeal, this is the first time I'm hearing about the standing issue. If I was understanding Duke's argument correctly, they were suggesting that only Duke has a right to have a problem with this case, but because of the Commission's order, customers owe just as much money because of Duke's imprudence as Duke does. Customers are being forced to pay $7.2 million, which is the same amount Duke is being forced to pay. So raising that issue is completely inappropriate.
He's just saying that the logic, and I mean, obviously, if they were prudent, why aren't they getting the? He's just saying that the logic of a prudence finding, if there was one here, that it would have led to the whole amount being recovered. I mean, so that's not a new argument.
All I was trying to say is that it sounded like a standing argument, and that would be the first time they're raising it here.
I think just what he was saying is that you're not asking for a different split. You're not asking for 70-30 or 80-20. You want all of it to Duke. And so that sending it back should it have been 50-50 is not really something that you're asking for.
Right, correct. What we're asking for is that the Commission to be required to follow their agency practice. And it's important to remember, no party during any portion of this case contested the amount of money at stake. It was always $14.4 million. That was in the briefs, that was in the testimony, that was in the order itself acknowledges that no party contested that $14.4 million is the amount in question. And on the issue of discretion, I would point out that the Commission is stating that they're entitled to your discretion, but they're also saying that their authority to act comes from statute, from this combination of statutes. And the Florida Constitution says that when an agency acts, this court can review that action de novo. So you get to decide. You don't owe them discretion on their interpretation of their statutory authority. Additionally, both the Commission and Duke have essentially asked you to reweigh the evidence in this case. OPC is not asking you to reweigh the evidence. OPC agrees with that in sum finding that Duke's actions directly led to this outage. And as far as the conflation of causation and prudence.
Let me ask you this. Is it your position that any time an employee makes a mistake that demonstrates in which I think we admit that the employee made a mistake, that demonstrates a lack of prudence by the utility?
No, Your Honor. The prudence standard accommodates this concept of mitigation and this concept of good actions on behalf of the utility. The prudence standard says what a reasonable utility manager would do in light of
So
the
it's
facts and
conceivable
circumstances.
that if you got a redo under this, then the person who's going to be smiling is the utility, rather than the consumers.
It would be interesting to see the
Well, it
commission
would be
change
interesting.
their finding of fact, but that is conceivable. But
Well, I don't know that it would be a change. I think it would be more like a refinement.
Maybe if they're watching, they could just rewrite it along the lines of what we heard.
and we'll just have to wait and see. Stay tuned, I guess. But as far as the prudence standard, if you're to your point though, as long as the utility establishes the burden of proof that they acted prudently, whether there was an outage, whether there were replacement costs, as long as they meet their burden of proof, they will recover their money. So it's the prudence standard doesn't require the utility to prove causation. It requires the utility to prove that their actions were reasonable and prudent, regardless of whether an outage or replacement power costs are incurred. That's how this concept of fairness is already incorporated in the burden of proof, and that's why the commission should have made that finding. And ultimately, just like when we flip a switch in our houses and the power is either on or off, a utility either meets their burden of proof or they do not. Here, the commission correctly found that Duke's actions directly led to this outage. However, instead of stating, therefore, Duke's actions were imprudent and they failed to meet their burden of proof, they introduced these foreign concepts in violation of all the parties' due process rights, Duke included, because they didn't know this was going to happen. And this is fundamental error. The court should direct the commission to enter an order finding that Duke's actions were imprudent and that Duke failed to meet their burden of proof. Therefore, they are responsible for the entirety of the stipulated $14.4 million.
Thank you very much.
Thank you.
We're adjourned.
All rise.